to be here chairing this session. And I'm really impressed with what I have heard about the different research being conducted by our ESRs. And so it's going to be a real pleasure also to listen to our 3 ESRs this morning. Eliona Jekac, Edmore Masendek, and Radina Ugrinova. And I thank in advance our respondents, Dr. Anna Arnsty Kerslake, Aurélie Baranger, and Dr. Alexander Hugenboom. So we all know how this works. 10 minutes for the initial presentation of the ESR, then 10 minutes for the respondent. Then I give the floor back to the ESR if they want to respond to the respondent for a few minutes, and then we open the floor also for questions and other comments from the audience. So without further ado, I give the floor to Eliona for her presentation.
Okay. Hi, everybody. My name is Eliona Jechai. Thanks, Paula, for the introduction. So I'll be presenting here to you on my research, which focuses on access to justice for disabled women who have been subject to gender-based violence. The research focuses in Iceland, and aims to explore the lived experience of disabled women and of those that supported them throughout the process of detecting, reporting, investigating, and prosecuting their violence. The research employs a human rights approach, combining disability studies, gender studies, and disability law and policy. That is, together with qualitative methods of semi-structured, in-depth interviews and document analysis of national and international law, as well as other documents applicable to this context. So far in my research, I have conducted 23 interviews with 3 groups of participants. The first one being self-identified disabled women. The second one being with professionals working within the justice system in the structures of reporting and prosecuting. And the third example of these would be rights protector officers, police, lawyers, prosecutors, judges, and so on. I feel very important to have met some of very key figures in Iceland. And as a researcher, meeting a police was terrifying. Anyway, that's a side comment. And then the third group of participants have been experts on the field and experts on the justice system, together with family members. I have used a grounded theory approach to analyze the data, and this far in my data analysis, the emerging findings will be discussed. So I'll be starting with the lack of reporting violence. All the disabled women that I have interviewed, apart from one, did not report their violence. Among the reasons were lack of accessibility. They recognized, they were aware that they were seen as non-credible witnesses. Among the reasons also the fear of media emphatic portrayals, and the potential dismissal and shame reactions from the community overall. All the disabled women also stated that it is important, however, despite the fact that they didn't want to report, it is important to speak and talk about violence. And that gets into my second findings on advocacy cuts across through the system. All the disabled women, as I said, wanted to speak and tell and talk about their violence. At the same time, they also advocated for choosing who you tell. And that was for fear of bad and negative reactions from whoever you told your story. Among the other advocates in the system were also the right protector officers, who advocated for a stage to be given to the disabled women to tell their stories. And while those stories were being told, for the society and the government to listen, to believe, and to start taking measures to address the violence these women have been subjected to. The rights protector officers were also advocating for the choice of disabled women not to report to be respected. most of us would say we have to report violence, we must, but we have to remember and respect that it's the choice of the individual to do so or not to do so. Other advocates included also individual access to justice workers. These would be police, lawyers, and the right protector officers, together with some prosecutors who currently are pushing and providing reasonable and procedural accommodation to the women that approach the justice system. Other advocates were also lawyers and police in a different context, advocating for more funding to be provided for police training, but also for the provision of technologies to facilitate the police reporting of the disabled women. Moving next, I've mentioned quite a few times the right protector officers and their importance in providing effective access to justice for disabled women. So the right protector officers are people assigned to certain regions within Iceland, with Reykjavik being the region that has the highest number of right protector officers. These right protector officers are assigned to support disabled people, in my context, disabled women, to protect their rights. These rights could be anything and everything, but in my context is to protect their right to be free from violence and the right to access the justice system, to report the violence they are subjected to. But their role doesn't only goes as far as protection, it also goes for the request and push for provision of reasonable and communication accommodations given the needs of the individual disabled women. Together with that, the role of the rights protector is also to inform and educate, but at the same time advise, for example, the police officers on how to facilitate, communicate, and provide an easy access to someone who wishes to report violence. So moving from that to my last findings, which is lack to training, and this spreads across. I would just really like to quickly refer to one of the lawyers that I interviewed, refer to one court case as being, we were lucky with the judge. Access to justice should not be based on luck. And it should not, when we as disabled women choose to report, we should not cross our fingers and wish upon stars that our case will be heard, that we will be believed and will be reaching the courts. So there was lack of training came across into lawyers, came across into the judges. One judge said, I don't need to be a judge, I don't need training on disability, therefore I'm not going to bother. So, and then there is, but I have to highlight that there is some training given to police officers. However, it is limited and more focused on perpetrators with disability and more so specific to perpetrators with autism. But there is very limited, close to non-existent training regarding victims of violence, those being disabled women. So I hope you've enjoyed it, my presentation, and look forward to questions.
Thank you so much, Eliona, and you did very well with time. So we're good. We're good. Your respondent, as far as I know, is online. Thank you very much for accepting this role, and we are all ready to hear your comments and questions to Eliona. Dr. Anna, please.
Hi, can you hear me?
Yes, perfectly.
Great, wonderful.
And see you too.
Oh, great, perfect. Eliona, that was a wonderful presentation. Thank you so much. And your work is really interesting. And of course, it's a really important area where not enough research has been done. So I'm very happy to see that you're doing work in this area. I mean, I think I have to start by saying I really like the methodology that you've taken, and I think your approach in general in combining disability studies, feminist studies, and it seems to me that you're really focused on the needs disabled women, which I think is absolutely the right focus. So really my comments, I think, are just delving a little bit deeper. So I just wrote a book that came out last year on legal capacity and gender. And in that book, I'm talking about how the law denies legal capacity on the basis of gender, specifically looking at women, disabled women, and gender minorities. And in the context of disabled women, but actually in the context of all the groups as well, I do talk a bit about how the denial of decision-making, and especially legal decision-making, often results or often manifests itself in the form of not being, of your choices and your decisions and your voice in relation to experiences of violence not being listened to, not being taken as credible for a courtroom or for a reporting process, and how that leaves women, disabled women, and gender minorities more vulnerable to abuse because they don't have that process. So I would love to hear from you if you have, and apologies if I missed it, but I didn't hear you talk about it. If you have touched on that right to legal capacity, and even maybe more broadly, sort of talk a bit more about that, the standing issue, which you did mention a bit, and how that plays in with the research that you're doing. And then my bigger question, which if you don't have an answer to is absolutely fine, is an issue around, so the term is carceral feminism, and I'm sure you've come across it. So the idea that the solution is prosecution. The solution to violence against women in general is prosecution, or violence in general, actually. And then of course, you know, that's the end game. I think so, and I bring this up because it's a challenge. I think in my own work, I've come across it many times in terms of advocating for this solutions to violence against women, violence against gender minorities, and especially disabled women and disabled gender minorities, and sort of creating solutions, but then coming up against this, I think, quite serious wall, which is prosecution the right solution, which is what carceral feminism would argue for, and I don't think it is, but I think it's a really interesting sort of, I think it's in a way the next step to where your research is right now. So I won't take up any more time. Those were just some of my initial thoughts after listening to your wonderful presentation, and again, just want to congratulate you on the wonderful work you've done. It really is very robust and really interesting work.
Thank you. You're helping me here with the time. Thank you so much. So Eliona.
Yeah, I would try to as quickly answer to that. A few remarks. Thanks, Anna, for your comments and your questions. I kind of don't really know where to exactly start, but as regards to your question regarding legal capacity, I would like to highlight the role of rights protector officers, that being the reason that their role literally goes under Article 12 and 13, which is legal capacity and access to justice of the CRPD. So a lot of, when it comes to the idea or the fact on some cases that disabled women, and more so those with intellectual disabilities, aren't believed, aren't seen as credible, aren't taken seriously, then we have to think about why aren't these being even listened to start with. And sometimes it's because the lack of training for the police officers, the lack of communication facilitators, and that being technology, assistive technology, and so on. And that's where also the right protectors come into with their knowledge about pushing perhaps or pressing poking the bear of the justice system, if I may say so, into facilitating the voice of the women to be listened, to be heard, and thus to proceed. With regards to also if the prosecution is the right choice, again, I would refer to the role of rights protector officers. I know I did not expand a lot, but when disabled woman either reaches out to a rights protector officer herself or reaches out to the police would contact the right protector officers, and then it is let down to, it is led to the decision of the disabled women to say, where does the case go? So some women have decided to take social services first. And once they've secured those, be it if the violence is happening at their home, if the violence is happening at their work, at their sheltered work, wherever it may be, once they get their services changed or their support services changed, or their staff member fired or changed, then they decide to either go to the police or simply get counseling or that. And that's where the right protector officer also highlights that we have to respect the decision of the disabled women, because the right to report is a right, and it should be individual, up to the individual to decide if they want to go further and prosecute if the case gets that far. But I wanted to also highlight that justice and what justice being served is different for each individual. The women I've interviewed highlighted some of them wanted the justice that we know, that being a court positive outcome. Some other women said, I just want a different house. I just want to get out of this place. Others said, I just wanted to get educated so I could be empowered, so I can stand on my own feet. And that's some area I will go into. I don't have the answer right now, but we can continue this discussion, and I hope we do, into what, if prosecution is the right answer, or what type of justice is justice to an individual woman. So I hope I answered your question and comments, and if not, I hope once I analyze even a bit more my data, I can give a better answer. Thank you.
Thank you, Eliona. So we would now open the floor for questions and comments from the audience. While you are thinking about your questions, I have a question. Because it's one of your findings, the lack of training across the whole justice system. So I would just like to hear you about any ideas you might have right now about how to go in terms of providing that training, how to structure, who should be involved. Do you have any thoughts about that already?
Yes. So as I said, one example is that lawyer referring to being lucky with the judge. And lucky meant that the judge allowed the provision of reasonable accommodation for the woman that drove the case all the way to the court, basically, for the disabled woman. Another example has been, for example, police officers referring to, yes, we got training on vulnerable people, full stop. And when I questioned who gave that training, what that training consisted of, there was no mention on different disabilities and different needs of individuals, different types of assistive technology, different techniques of doing the interviews, or even as simple as physical accessibility of the room where the interviews were taken, or police statements. So I would combine all of your question into, it is absolutely important to know who will give the training. And in the case of Iceland, the police officers I've interviewed are quite an important advocates. They're pushing some from personal motivation, some for motivations of providing access to absolutely everyone, and that will include disabled people. They stated that their training is done by some structure in UK, They did not label it for data protection reasons, or I don't know. But there is training. So if there is training on how to deal or facilitate reporting or protection or defense for perpetrators with autism, as they refer to, then there must be training for victims. And I do have a play on language, I guess. We always say a defendant is innocent till otherwise proven, and then my take would be a victim, speaking in justice terms, I guess, or in current justice terms, a victim must be a victim until proven otherwise. So we must believe when somebody reports violence, we must believe, and then let the evidence or try and find different evidence that supports the voices. And by different, I mean, there's always the example of, well, somebody cannot tell the time, and therefore the evidence does not consist with the what they're telling us, that this happened before lunch or after lunch, or happened at 2 when in fact it happened at 4, that the evidence shows otherwise. So one of the rights protector officers said to me, we need to deal with this technical at the very beginning, and that is through training the police officers to look for other ways of finding the time, for example, of when the incident or the violence happened, by saying, did you have, in cases of residencies or group homes, for example, did you have your tea? And usually life is programmed for you, unfortunately, in institutions. So before the tea, or what TV program was on, and if the police officers have some training on these alternatives, or I would say accessible way of getting evidence, then that should be provided. Disability-based training should be the key. So.
Thank you, Eleona. I think we have also some questions from the online audience. Oh, and here, but I saw something also there too. Yeah. So yes, Francis.
Eleona, Frank Connerty, and thank you very much for that. That's a really, really important area of research. And you've probably answered it there a bit in your answer to that question, but I was just wondering to what extent have you surfaced what I would call levers to the intersectional amplification of barriers to justice? Because we have violence against women and girls and well-documented barriers to justice. And then when we bring in the, women with disabilities, that intersectional amplification that can occur. Have you surfaced, significantly in any way, particular levers in relation to that amplification? I think you might have cited one there in terms of, disability-specific training and stuff. But I think it'd be that aspect is to me, I'm quite interested in it. And then I'd also ask you in relation to the subjects that you've been examining, have you extended from violence against women to violence against women and girls? Because then you're going into intersectional in relation to attitudes towards people who are minors as well. Just wondering if you'd looked at that.
Maybe we take also the 2 questions from the online or comments.
Yes, so Eleanor Flynn and Keelan Barry. So if Eleanor wants to go first.
Okay, Eleanor, do you want to go first?
Sure. Yeah. Thanks so much for your presentation, Eleona. Your work is so interesting. I just wondered if you might want to say more about the procedural accommodations that are available for disabled women if their case does make it to court in Iceland. So, for example, would that include the use of intermediaries, communication assistance, or a different structure to the trial, perhaps more scheduled breaks, or any other measures that you're aware of that they're actually applying during the procedure?
Thank you, Eleanor. And Keelan. There's another question from Keelan.
Hi, Eleona. Thank you so much for your wonderful presentation, such important research. I was just wondering if you could expand some on any challenges you faced in your methodology and recruiting interviewees, particularly people maybe from intersectional backgrounds, and then what your reasoning was in choosing grounded theory. Thank you so much. It was a great presentation.
So thank you. And the challenge now, Eliona, is 4 minutes for 3 questions.
Okay. Well, I'll try. So, Frank, yes, yes and no is the quickest answer. So, I limit my research to women who are aged 18 and over. So I guess I'm not choosing definition who's a woman, who's a girl. But as I said, is self-identified disabled women. So whoever wishes or accepts my invitation to take part, I let it up to them to the way they want to identify. And throughout the interview, they might refer to a woman or a girl as to themselves. So with regards to the intersection, absolutely. That's why I kept referring to the disability aspects, but also the gender aspects. It's gender-based violence. And as many research has shown, there is gender-based violence that women face, but there's also disability combined with the gender violence that we as disabled women face. And I could go providing an extensive list of those type of violences, but I don't have time, so I can do that in the break with you. With regards to procedural accommodation, Eleanor, well, the Rights Protector Officer, although they're not listed as such, they are, in my arguments, a procedural accommodation for disabled people, and thus these would be for disabled women. With regards to specific accommodation provided in court, I have been provided examples such as change of courtroom because the illumination wasn't right or there was too much brightness. When there was constructions going on nearby, they changed the courtroom. As regards to individual reasonable accommodation, there has been extra time provided to disabled women to think and respond if they needed so. There has been microphones, which is not usual apparently, provided for disabled women who their tone of voice is quite low. Louise, right now there is some debate going on about a support person being allowed in court while the disabled woman is giving her statement. So these are some of the examples I can remember on top of my head right now. And with regards to your question, Keelan, as a disabled woman doing research, I face my own, I guess, challenges as a screen reader user. So that's one there. But with regards, and I try and keep this very, very short, methodology, COVID. Talking about a sensitive topic in a very difficult time is not easy. So I chose to stick to the interviews, particularly with disabled women, in person. And I was like a watch cat, looking at when there was a window of opportunity with regards to the restrictions so that I can interview the women. And reason for choosing grounded theory approach is simply I wanted to create theory from the data, not the other way around. I wanted the data to speak to me and take it from there into voicing and bringing out the voice of and the experience of disabled women in this context. So I hope I answered all of them. Thank you.
Thank you. You were amazing in answering all these questions in 3 minutes. Thank you so much. We need to move on to the next ESR, and that will be Edmore, who is going to present us his project on voice and access to justice, defendants with mental health conditions and learning disabilities in court. And Eddie will have the support of his PA to make his presentation.
My name is Edmore. I've asked Maria to my baby to my present to me in the interest of time.
Yeah. Is the microphone okay? No. Start again.
Hello.
Now it's working.
Hello, I'm Ed Moore of Maria to help me by reading my presentation in the interest of time.
My research focuses on the communication support that is available to defendants with mental health conditions or learning disabilities during criminal proceedings in England and Ireland. It looks at two things. First, it looks at the extent to which existing legislation provides for the provision of communication support to defendants with mental health conditions or learning disabilities during criminal proceedings. It argues that existing legislation in both countries, particularly the equality legislation, can be used to ensure the provision of communication support to defendants with mental health conditions or learning disabilities during criminal proceedings. Previous research in Ireland largely focuses on specific legislation and does not explore how equality law can be used to supplement the primary legislation. Furthermore, the role of personal advocates in the Irish criminal justice system is an emerging role, and very little has been written about it in existing literature. Second, it also looks at the experience of defendants with mental health conditions or learning disabilities during criminal proceedings. Previous studies have not always managed to include the perceptions of defendants with mental health conditions or learning disabilities on this subject due to difficulties in recruiting these participants and the many adjustments required to successfully include them in the research. I made these adjustments and it took me a long time to recruit participants. In the end, I managed to interview 9 former defendants in England, but I did not manage to recruit any participants in Ireland. From the legal analysis, my findings were that in England, the Coroners and Justice Act 2009 provided for the examination of a defendant through an intermediary. However, these provisions have not yet been implemented. Therefore, courts rely on common law to appoint intermediaries for defendants. Courts may exercise their inherent powers to direct the appointment of an intermediary to assist a defendant giving evidence or for the entire trial. An example, for giving evidence and understanding what is happening during trial. However, defendants' access to intermediaries has been problematic due to inconsistent guidelines, resource constraints, and the lack of a register or accreditation system for intermediaries for defendants. In addition, the Equality Act 2010 provides for the duty to make reasonable adjustments for disabled people and to have due regard to the need to eliminate unlawful discrimination, advance equality of opportunity, and foster good relations under the public sector equality duty. This creates an obligation to ensure the right to effective participation by providing support with communication to both claimants and defendants with mental health conditions or learning disabilities. Ireland has several pieces of legislation which are relevant to the provision of communication support for defendants with mental health conditions or learning disabilities during criminal court proceedings. The Criminal Evidence Act 1992 provides for the appointment of an intermediary during criminal court proceedings. However, it only provides for the appointment of an intermediary for a defendant in cases involving offences which are of a sexual or violent nature, but not in all other cases, as in the case for victims. Since this act came into force, intermediaries have been used twice in Ireland, and it was by victims both times. Defendants have never used an intermediary in court. That could be because it is not clear who should fulfill the role and how. There are resource constraints, and the legal professionals are reluctant to appoint intermediaries, in part because they are not aware of the role of an intermediary. Defendants tend to rely on personal advocates, which are provided for under the, do you know how to pronounce that? The Comharlip Act 2000, Ireland, and the Citizens Information Act 2007. However, personal advocates seem to be available, thank you, only to help those most in need and do not have a right of audience in the court. Ireland's national equality and non-discrimination legislation is also significant in ensuring that the rights of defendants with mental health conditions or learning disabilities are protected in the court system. It also requires certain actions to be taken towards this end. Defendants should be held as equal before the law in the terms of Article 14 of the Constitution. Defendants should not face discrimination in accessing courts in the terms of the Equal Status Act 2000-2004. Court services should be made accessible to defendants in terms of the Disability Act 2005. Courts should protect defendants' rights and equality in terms of the Irish Human Rights and Equality Act 2014. From the interviews, my findings were that defendants with mental health conditions or learning disabilities sometimes go to court without the support that they need. Most of my participants said that they did not understand what was happening. They also said that they did not understand what was being said during the court proceedings. They found the language of the court difficult to understand. Some of their solicitors did not allow them to give evidence in court or encourage them to plead guilty, even when they were innocent. These findings are consistent with what is already known about the barriers which defendants with mental health conditions or learning disabilities face in the criminal justice system. There is a need to address these barriers, and I suggest that the following measures need to be taken. First, there is a need to create a statutory provision for defendants to access intermediaries in line with equality legislation in both countries. The shortcomings of existing equality legislation also needs to be addressed in this process. Second, there is a need to develop guidelines for the implementation of the role of an intermediary for defendants in both countries. This needs to be backed by the provision of adequate resources for the implementation of this role. Third, there is a need to train legal professionals about reasonable accommodations and to address existing attitudinal barriers in relation to the provision of communication support to defendants with mental health conditions or learning disabilities during criminal proceedings. My research can be used to support DPOs and other civil society organizations who are advocating for the creation of statutory provision for defendants to access intermediaries in Ireland in particular. The research can help them see how this is related to the equality legislation and incorporate these arguments in their advocacy efforts. In addition, they can draw lessons from the situation in England and try to avoid the mistakes that have been made in that country.
Thank you, Eddie, and thank you, Maria, for supporting Eddie in this presentation, and again for keeping the time so well. Thank you. So without further ado, I hand it over to Aurélie Béranger, who is going to make the comment and the response to this presentation.
Do you know how to switch on? Is it on?
Yeah, I think it's
okay. Sorry, I didn't see the light. So thank you very much, Anne-Marie, for this presentation. I think it is really important and really interesting. So I'm Aurélie Béranger, and I work for Autism Europe. And you probably know that autistic people, according to research, according to available data, are particularly likely to come into contact with the criminal justice system, either in the position of victims or defendant. So for us, it's a very important area of research, because we know that there is indeed a lack of accommodation and a lack of recognition of their needs when coming in contact with the justice system. So your research, I think, is really key and really bring a lot of value to indeed for advocate in Ireland, but also beyond in other countries. So thank you very much. I would have maybe a few questions for you to know if you've had the opportunity to look into that. So I was wondering if you're aware of any research or any data regarding the added value of having such an intermediary for autistic people or people with mental health difficulties or learning disabilities? How do they really help people to with their communication difficulty in particular? And maybe is there any comparison between having an external intermediary or a family member or an advocate from that already knows the person? So that would be maybe one question. Is there any evidence that intermediary help with the, for example, accuracy of the evidence that is given and so on? And then would that help, you think, to make them more readily available for the person? According to your research, is there also maybe a correlation between the availability of intermediaries that I understand is at the discretion of the court, and maybe the fact that people have been trained into accommodation, necessary accommodation for disabled people? Another question, sorry, I'm maybe firing up a lot of questions, but have you also considered the issue of screening of people with mental health issues, with autism and learning disabilities? Because we know that, for example, many autistic people are undiagnosed. So is it something that came up in your research? And do you have any suggestion to address this? And yeah, maybe I'll stop there for now. Thank you very much.
Thank you. So, Eddie, your comment first or response to these comments.
Thank you for your comments. I think the role of an intermediary was established first in England, and research shows that their role is to help in the communication in court. What they do is, before going to court, the person is identified as having a communication challenge. Then some communication specialist, either a speech therapist, a psychologist, or a teacher or somebody, is identified to assess the communication needs of the person in court. Then when they advise the court of how to question the person, how to adjust the language of the court so that it suits the person. And during the court, if the court asks a question which is too difficult for the person to understand, the intermediary can intervene and ask the court to rephrase the question, or the intermediary may explain the question to the individual. And vice versa, if the person speaks an answer which may not be understood by the court, then the intermediary may then explain what the defendant has said to the court. So there are support mainly is communication, but also they make recommendations like whether the court should be public or private, whether the person requires frequent breaks for understanding, and also facilitate communication between the lawyer and the court participant. The difference, though, is that in the case of a victim, they are entitled to this is in law, but in the case of the defendant, it is currently largely dependent on the judge because there are no statutory provision for it. So assessment have been done and shown that when victims go to court with an intermediary, they are more likely to be able to give their evidence and be there's a high success rate, not of the case, but being able to participate. So the argument is that for victims, for defendants, this facility is not available to them, and it should be available to them for the very reason that their impairments are the same, so their needs are the same. Yes. Then your questions on whether they should be supported by a relative or an advocate, I think the challenge would be the neutrality of the relative or an advocate. So that would be a problem in court. So usually when relatives support the person in court, they are always limited to explaining what is happening on the sideline, but not really being involved in the court proceedings. So the limitation is that the person may require support with the communication in their evidence, and so intermediaries might be better at doing that.
The screening, whether the screening.
The screening, although my research didn't go that far, I think there are a debate about the medicalization of the entire process, because sometimes courts tend to rely too much on medical evidence rather than on the person's needs, which might not be anticipated by medical evidence.
Thank you, Eddie. So, are there questions from the audience here? I see there are 2 notes there in the chat, so maybe we can start with those.
No, they're not for this session.
No, they're not? Oh, not for this session. Okay. Do you have a comment? Do you have another
No,
Question or
well,
comment?
I mean, it's a very interesting topic. So, I mean, I don't know, Eddie, if you also have investigated how this relates to other form of reasonable accommodation for people, such as, for example, for autistic people, accommodating sensory issues or these kind of things, or if you but I would like to thank you for your answer, and in any case, and for this research. But I don't know if you want to add something, maybe about other
Okay.
reasonable accommodation.
It seems that Eleanor has. Oh, okay. So apparently, yes, there are two, just a second, Eddie, because apparently, yes, there are two other comments or questions from the online audience. And I think the first is Eleanor, and then we have also Radina.
Great. Thank you so much, Eddie. Your work is so interesting. And again, I'm so sorry you weren't able to recruit participants in Ireland, but such is life during a pandemic. But I wanted to ask you about your views on providing equal accommodations to disabled victims and disabled defendants. I know your focus is on defendants, but you've obviously looked at the accommodations that are available to victims or witnesses as well. So do you think that the arguments that are being made in, do you encounter more resistance to the idea of extending accommodations available to witnesses to defendants, or is it the other way around from your research? What do you think people are most resistant on? Because, at a general level, we could say, well, you should just extend the same accommodations to everybody, and this would solve some of the procedural, due process concerns. But sometimes criminal defense lawyers don't find that to be a convincing answer. So I wondered what your view on that situation is. Thanks.
And maybe we take also Radina's question right now. Radina?
Hi, Eddie. Thank you so much for the wonderful presentation. So I have a question relating to the point about the medicalization that is often present in a judicial context. That happens quite a lot in mental health law. Judges tend to pivot to a very medical model of disability, and they prioritize evidence provided by medical professionals, oftentimes over the lived realities of disabled people. So I was wondering, because this is such a pervasive issue in a judicial context, do you have any suggestions on how we as disabled activists and also researchers can work towards perhaps bringing more light to this issue and providing strategies or working on strategies to kind of combat this? Thank you.
And there is another person from the online audience that wants to raise a question. Jolene?
Hello,
Yeah,
can you hear me?
please.
I'm Jolijn Santegoets. I'm a board member of the European Network of Users and Survivors of Psychiatry, and also in the World Network. And my question is, what are your views about the South African model of truth and reconciliation and their approach to justice, and especially in terms of identifying the needs? Yeah, that's my question.
Okay, so 4 great questions for you, Eddie. And just about 6 minutes.
Thank you. I will start with the first question about reasonable accommodation and sensory people with sensory impairment. I think the role of the intermediary it covers people with most sensory impairment. It's only that I focus on 2 specific impairment, but the role is broad enough to cover anybody who has a communication need or a cognitive disability. And because they, like for people with mental health condition, there's a recognition that the environment may affect their communication or their ability to participate in the trial. So that is part of the assessment that is done, understanding the individual and how they they perform under stress and under different conditions and making accommodations to ensure that they are able to perform as effectively as possible during the court process. And then the second review on extending the accommodations that are available to victims to defendants. It is an argument that I support, but there seems to be a kind of resistance because there seems to be a belief that victims are entitled to their accommodation, while defendants are seen as the bad guy who is not entitled to any mercy. So that needs to be addressed. That attitudinal barrier of seeing of the portrayal of the defendant needs to be addressed in order to effectively ensure that even if the accommodation available to victims are just extended, that perception doesn't hinder the effectiveness of them of the accommodation. Then the third issue was the medicalization of of people with mental health conditions and other things. I'm not really sure how this could be addressed, but this is a long-standing issue and it needs further exploration in research as well as in advocacy to see ways of changing the views of judges on the issue. I think it goes back to the need of training of legal professionals to ensure that they have a better understanding of disability issue. I think the final comment was on my views on the South African model on about the truth and reconciliation justice. I'm not really sure because it wasn't part of my research. Thank you.
Well, thank you so much. And we did it on time. Amazing again. Okay, so we move on to our third ESR presentation from Radina. And her work is on disability in court, how European courts understand disability. And Radina is online, so she will be doing her presentation here. We'll see her on the screen, I suppose.
First, can everyone hear me?
Yes, we can hear you very well, Radina,
Perfect.
and we can see you too.
All right, perfect. Thank you so much. So today I will focus on a brief examination of a couple of trends relating to how European courts define the concept of disability in an employment context and in the context of EU non-discrimination law. So the way I'd like to proceed is I'll first briefly explain what my project is about, and then I will focus on the key findings I have put together in this presentation. I will be reading out each finding from the slides for the purposes of accessibility and inclusion needs, and then I will elaborate on each point. So now I'll start with what my project is about. Basically, for the last 3 years, I have been examining how the European Court of Justice and the courts in two states, Denmark and Germany, define the concept of disability in the context of employment. So when a claimant brings forth a claim for discrimination on the basis of disability, I'm interested in how courts define who is disabled and on what basis that person is disabled. And I've used doctrinal legal analysis to do that, combined with systematic content analysis, with the purpose of uncovering trends in the judicial decision-making as to how courts view disability in an employment context and how exactly they define which claimants can be categorized as disabled and for what reasons. So now I will move on to the findings I've made. The first one is that courts engaged to a very limited extent with the text of the CRPD, the Convention on the Rights of Persons with Disabilities. And that is quite an important finding because the CRPD is basically the most important human rights instrument focused on the rights of persons with disabilities. So it was interesting to me that courts in the EU don't tend to engage very extensively with specific articles or specific concepts stemming from the CRPD. Usually what we see in the case law of the European Court of Justice is that the court would recite Article 1 post HK Denmark, and then basically there is very limited interpretation of the actual articles of the convention. Now, domestic courts, what they do is they may more often refer to the case law of the European Court of Justice, and there the interaction with the CRPD is even more limited. So there are two ways in which this can be explained. One is that these courts are not trained or these judges are not trained in international human rights law, and there is some unease with actually interpreting articles of international human rights law. The other one is that there are slightly different aims when it comes to international human rights law versus EU non-discrimination law. So in international human rights law, there is an assumption that human rights obviously hold the highest priority in international law in general. At least on paper, there is no kind of hierarchy of different areas of law. So human rights law has its own priorities of protecting human rights. Now, in EU law, it is more common to see a balancing of different rights and interests for the purposes of basically securing the optimal operation of the internal market. So it is possible that European courts feel more comfortable with engaging in this balancing act of rights and interests, as opposed to what international human rights law traditionally does, which is to focus specifically on the human rights aspect. Now, the second finding that I have put in the slides is that courts lack an understanding of the lived reality of persons with disabilities. And this may lead to a formalistic definition of disability and a flawed decision-making process in determining whether a claimant is disabled. Now, what I mean by this is that judges often define disability in a very abstract manner, which is quite removed from the lived reality of disabled people. And two cases that are quite good examples of this trend are case Z, which is basically a case that came before the European Court of Justice a few years ago, where the claimant couldn't conceive and give birth, so she chose to have a child through surrogacy, and she was not allowed to take parental leave because basically surrogacy wasn't covered under the domestic legislation. And the court determined that she was not disabled because basically she was not restricted in her participation in employment. And I disagree with this argument. I think that this is flawed. Yes, in principle, she was not restricted in a way where she was said, you cannot hold a job because you cannot have a child through surrogacy. But in effect, she wasn't able to enjoy the full spectrum of labor rights because she was not able to access parental leave simply because she chose to have a child through surrogacy. So in this context, I do believe that the court did not go deep enough in its analysis of what the lived experience of being disabled actually is and different nuances. The second case that came before the European Court of Justice is Kaltoft, and very briefly, this case concerned whether obesity can be considered a disability for the purposes of EU non-discrimination law. And there the court basically omitted examining kind of the prejudicial treatment and the attitudinal barriers which many claimants face because of the way that they look and the association that their employer may make between their appearance and their capacity to perform a job. So there, again, the court didn't go deep enough in its analysis of what it means to be disabled actually in reality outside of the confines of the law. And on this basis, my third finding was that judges need to receive additional training in the areas of how they interpret the CRPD, both key articles and key concepts embedded in the CRPD, and the socioeconomic and cultural contexts in which inform the lived experiences of persons with disabilities. And the way I believe this can be achieved is through two strategies. So the first one is to actually provide training to judges. Now that is quite challenging because these are actors who are quite powerful, both legally and in a sociocultural context. So Professor Lisa Waddington actually suggested that training provided by judges to judges in this context can be very useful because of the credibility that judges may see in being trained by other judges. Now, the second, I think, change or reform that can be very useful is to re-examine how law is actually taught in law school, because I have 3 degrees in law and I have very rarely been taught concepts that do not directly stem from the legal discipline. And I do believe that since the law is concerned with social order and the well-being of the people governed by the system, it can be actually quite useful to delve into disciplines such as philosophy, specifically focused on human rights law, sociology, political studies, and so on, to kind of expand the understanding that we have about the law and the role of the law in governing people and in providing the opportunities for people to live a better life. So my time is up and I'll stop there.
Thank you. Thanks, Radina. Excellent mastery of time as well. So I hand it over to Dr. Alexander Hugenboom, General Legal Counsel at the Netherlands Institute for Human Rights, who is going to respond to this presentation. Please.
Thank you, and thank you for inviting me, and thank you also for the this is on, right? Yeah, interesting presentation. What I very much enjoy as well is that in this focus, you don't just focus on the European courts, meaning the Court of Justice, and also look at but rather you also look at the domestic courts, because it seems to me that the potential for change that was also discussed this morning has much more. Yeah, there's much more potential for change at the lower courts, especially like the first instance courts, I would almost say, than there is at the highest courts or Supreme Courts or even the Court of Justice, because that takes a much longer route. And often at this point, then the issues become so abstract that they don't connect anymore to the lived realities, as you pointed out. And this is actually also one of my comments with regards to the Court of Justice and what you seem to expect from the Court of Justice, because you say like, okay, in defining disability, it's too formalistic and doesn't engage enough with the lived realities of the persons involved.
Can I ask you to speak slower,
sorry, yeah.
please?
This is always my issue.
For our interpreters.
So what I'm wondering a little bit is that can Court of Justice in this respect actually change, in a sense that is, of course, there to answer questions of law posted by domestic courts in essence, and by definition not a court of facts. So it seems to me, from an institutional point of view already, it's sort of like on the back foot in trying to engage with the lived realities of the applicants, because applicants may not even be there at the hearing, so to speak, literally, because normally these issues are basically fought out between the government of the member states. Like not always that the applicant is going to be present or even represented in these proceedings. So I was wondering a little bit, like from this institutional point of view, if you have any ideas in this respect as well, to bring in these lived realities within the court system at the Court of Justice level. Then I was also wondering more generally if we could reflect a little bit on the recent developments, whereby you see that the court has grappled a little bit with, on the one hand, disabilities and the concept of the sort of essential functions of the occupation. So we have recent cases with starting with let's say the disabled person, or like had an auditory disability in a prison context and filled certain standards in that regard. Then you have the person with a visual impairment also in legal context as a lay judge. And then recently, of course, with the XXX case versus HR Rail. So with the person with the pacemaker who could not work in the basically in the occupation that he was initially assigned to. And there, I think you see the court engaging more, maybe a little bit with lived realities and the need to question standards that are applied without regard for the individual circumstances. And I was basically wondering how you see this development, and if that's a positive maybe development when compared to the more formalistic reasoning that you pointed out on before. And actually, I'll start with this maybe. Yeah, you can respond.
Thank you very much.
So, Radhi, now to you again.
Yeah, thank you very much for the comments and the questions. So regarding your first question, that is a constraint for the European Court of Justice, because essentially they're constrained by what questions are posed by the national courts, right? And as you said, they are not a court of facts. So the facts have already been established in the national court, and the European court basically has to work with that. I do think that there are two things that can improve. So the first one is actually going back to the national courts and working towards increasing awareness of the importance for national judges to understand the lived experiences of disabled people, and to kind of re-examine how they themselves define disability and who is disabled, because this would influence the type of questions that are actually posed to the European Court. Now, the second thing is more abstract, and this relates to the court itself. I do believe that even though the court is constrained by this procedure, it's still valuable for any court and any judge to have more awareness that the claimants that come before them may have a very different reality to what this specific judge is used to. Because at the end of the day, yes, judges have a professional duty to be neutral in their decision making, but we're all human and we can't leave our lived experiences and our worldviews at the front door of the courtroom, right? So I think that actually providing training also on unconscious bias can be very useful to, again, both national judges and judges on the European level. There was actually an excellent example recently from the US where I think a district judge ordered himself to receive training on discrimination on the basis of sexual orientation, because in his opinion, he said, I am not qualified to preside over this case because I don't understand the lived experiences of people from the LGBT plus community. So I think that while this would be more abstract on the European level, there is still merit to that. Now, with regards to your second comment, I do believe that oftentimes in employment, there is a lot more focus on what disabled people cannot do, and the presumption that disabled people are inherently more inefficient or inherently more expensive than on the things that disabled people bring of value to their employer and in general to the labor market. So I do view these developments as going in the right direction, because at the end of the day, I mean, different disabilities will have different limitations, that's for sure. But at the same time, there are certain kind of advantages in some cases to being disabled. So for instance, I'm a disabled researcher, and for me, it is a lot easier to find disabled participants in some contexts who would like to work with me, because there is more trust at the gate of actually starting to engage with people whom I don't know. Some disabled people feel safer to work with a person who they do not know, but know that she is disabled in my case. Also, I have kind of I view it as an advantage, the advantage of having a more critical approach to, in this case, examining case law compared to someone, for instance, who has not had my lived experiences, because obviously when I read these judgments, there is an element of this is my research and this is my work, and I have to try to be as neutral as possible, but there is also an element of emotion, because I oftentimes am affected by what I'm reading, and I view this not as a flaw, which is how traditionally this has been viewed in the labor market, but as a strength, because this gives a different perspective to my work than to what may be already out there. So I think that focusing on what disabled people bring to the labor market and to their employment situation, as opposed to what their constraints are because they're disabled, is the way to go.
Thank you. Thank you, Radina. So are there questions from the room? I think I see some comments in the chat. Yeah.
Yeah, Eleanor would like to ask a question.
Okay, Eleanor.
Hi, thanks very much, Radina. That's a really interesting presentation. And of course, I think you know from previous discussions that I'm really interested in your work. So my question is about, I suppose, how we might work to get more disabled judges on the bench, particularly in the Court of Justice, but also in the national courts, because we've identified that that is a place of particular possible change. And so what do you think are the barriers for disabled people ascending to positions of power within the justice system? How could we work to dismantle them? And perhaps also encourage people who are already in these positions who may not openly identify as disabled to feel confident to do so, that doing so does not undermine their legal authority or interpretation in any way. So I'm interested in your thoughts on that.
Thank you very much. So for me, the issue boils down to higher education and access to education, because disabled people are disproportionately, in my opinion, represented in higher education. We don't have the same economic resources as a lot of our conventionally able counterparts, which is already one barrier. Another barrier is that oftentimes the requirements for accessing higher education are not necessarily suited to the lived experiences of some disabled people. So it is difficult for them, even if they do have the economic resources or there is no higher economic barrier to entry. It is difficult for some disabled people to meet the generalized requirements, the standardized kind of tests that are put out there for them to be able to access universities. And then the third issue is that academia, unfortunately, still is not very welcoming to disabled people. So I actually established a network for disabled students and researchers at Maastricht University, which aims to support and kind of provide them with means for advocating for themselves within the university. And what a lot of students share with me is that enormous strides have been made in recent years towards inclusion at the university level of disabled students, but it is still not enough, because at the end of the day, disabled students don't just go through the general, quite arduous process of studying. They also have to manage their individual circumstances. And that's kind of a double burden. And that's still not accounted for in many academic settings. So I do believe that actually removing some of these barriers to access to higher education, so that more disabled people can access the training necessary to enter the legal system as professionals, whether that would be lawyers, prosecutors, judges, whatever, is a very important step towards addressing this disparity. Now, with regards to whether or how we can encourage people to come out as disabled, I don't know, because I don't believe that as a disabled person, you should necessarily disclose that you're disabled. I think that that's a very personal decision, and that's made on the basis of whether it feels safe for you to disclose. Maybe the thing that can help is to work towards removing some of the attitudinal barriers towards disabled people in employment, because as you pointed out, this is also a question of, are you qualified for your job because you're disabled? Are you good enough in this field because you're disabled? So for instance, I've had interactions with people who have questioned whether I'm capable of being a researcher because I'm disabled, because they perceive me as biased. So that's a very difficult barrier to address, because obviously, if you belong to any marginalized community, you cannot separate yourself so easily from your identity, and that informs inadvertently a lot of the things that you do even in employment. So I think that having a wider discussion about the fact that personal identity and professionalism are not necessarily linked, and that disability is not something that informs in a bad way your working relationships or your working capacity, is kind of the cultural shift that we need in general in employment. And in the legal field, that's even more difficult to achieve, I would say, because of the very extensive focus on professionalism, and specifically professionalism from a conventionally able perspective. I don't know if that answers your questions.
No, it does. Thank you. That's really, I completely agree that, of course, people should not have to identify or disclose unless it's safe for them to do so. And I think, you know, as Michael Perlin and others write about, there's high instances of whatever you want to call it, psychosocial disability. Some people call their experience different things, but of that in the legal profession and among the judiciary as well. And yet people often don't disclose until perhaps after they've retired, when they feel that it's safe for them to do so, and their bias will not be called into question, or their ability to perform their role as a judge will not be questioned. And that, I suppose, speaks to the structural changes that we need to work on in society, in the legal profession, in the justice system, to try to ensure that people would not be so afraid to disclose, and that it could be seen as an asset and a strength in how people approach their role, and as part of increasing diversity in the profession, which again, there is often an acknowledgement of the need to do without the kind of steps to dismantle those structural barriers that would be really needed to reach that goal of greater diversity in the profession. So thanks for that. Those are very thoughtful answers. Thank you, Radina.
Thank you. I think we have another questions in the room. Another question? Yeah.
Hi, thank you, Radina. I'm going to ask a question which I'm sure feminists in the United States are asking themselves now, given the recent revelations. And that is, as an equality-seeking minority group, would you suggest strategically that maybe using the courts may not be the best way of proceeding? And given the kind of perhaps entrenched, unmovable resistance to understanding the lived experience in a judicial discretionary context, where a judge is in a position to make a ruling that's authoritative and inputting into that decision something that may or may not be willingly put in. I mean, the judge can say, I don't want this information, I want to be neutral, etc. Do you think strategically the community might reconsider the strategy of using anti-discrimination law in courts and move in other directions, more political and so on? I mean, is your research pointing you in a direction which in a sense is pessimistic with respect to the efficacy of equality-seeking groups in the judicial context?
Can I just add something to that point? Because as a sociologist, I was thinking that in the end, judges are persons and they live in a society. And of course, it's very important to have specific training for them, but they reflect also the values and the views of the society they belong to. Although, they try to do it in a professional way and then they make their judgments, but there's the unconscious bias that you talked about also. It's there, and we know that. So I would be very interested in hearing your reaction to all this.
Thank you both for the comments and the questions. So I'll try to answer very briefly because I'm almost out of time. So I do believe that in certain contexts, it is incredibly useful to actually go through the court system and basically courts can make quite a powerful statement about the importance of certain rights and freedoms in a society, right? So I do believe that there are instances where this is very useful. However, I do share the kind of skepticism that courts might not always be the best option, because what Professor Quinn actually said during the first event is something that I consider very pertinent. The general political discourse regarding equality and equity and access for marginalized communities to certain rights and certain resources needs to change first, so that basically the whole society moves towards in a slightly different direction. Because I do agree with you, Professor Pinto, judges reflect, at least to some extent, the general attitudes of the society in which they live and they practice law, right? So it is very important to have kind of a wider socio-political and even economic change first, before we can actually rely on courts to make the rulings that would be beneficial to us as a marginalized community. I hope that answered your question.
It does. Thank you so much. I think we are on time to finish this session. So I just want to thank again our ESRs who present their very interesting research, to the respondents who also raised important and relevant issues, and to all of you who attended and participated with your questions, either lively here in the room or online. Thank you so much, and let's have lunch. Thank you.